Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about divorce and family law. Joining me as always is my co-host, Jesse Barrientes. Jesse, how are you?
I'm doing fantastic, Dave. How about yourself?
I'm doing well.
Beautiful evening.
There's been some big changes in divorce and family law
there
over
sure
the
have.
last year or two, which are just starting to take root now. So let's jump right in. What happened with the legislature where they overhauled divorce?
Well, a lot of things changed. Before it was called custody and visitation, and now it's called an allocation of parental rights and responsibilities, and it's broken up into two prongs. One is decision-making, and the other is parenting time. Decision-making covers education, extracurricular activities, medical decisions, and religious decisions. And any one of those four areas can be divided anyway, either by agreement or after hearing based upon what the judge hears, he or she can order it. So you could have one person that's solely responsible for education and one person solely responsible for religion, and both parties jointly responsible for making the decisions as it relates to extracurricular activities and to medical. Or it could be one person who is solely responsible for making all those decisions, or they can be jointly responsible for making all those decisions, or any other combination therein. But Dave, let's call a rose by any other name is what? A rose.
Well, that's a two-part question here.
Sure.
Why the change, and has it been beneficial?
Now, I'm hearing that it kind of has been beneficial. Let me tell you why the change. People get stuck on terms, okay? We have these ultimate terms, and we think if I have sole custody somehow, and I can't tell you how many times I've heard this from clients, I'm losing my rights as a dad or as a mom, I got sole custody. No, okay. The old law before, and this all changed on January 1st of 2016, and before there was joint and sole custody, and joint custody essentially meant that the non-custodial parent, the parent that didn't have the physical possession of the children most of the time, had a say-so in the upbringing of the children and the decisions as it related to, actually three areas, but really everything else too, the ones that we talked about, okay? So religion and medical and education, okay. And in a sole custody situation, again, the non-custodial parent who didn't have most of the time with the children, didn't have a say-so in those areas. Now, everything else was the same, and typically what you find is that when in a household, generally, I don't know what to say it. And again, I say generally, it's not always the case, but it's the mom, because generally the dad's working, and so the mom's taking care of the kids, and she's bringing them to the dentist, and she's bringing them to the doctors, and she's setting all these things up because dad is hard at work providing for his family. Now, sometimes, again, as it happens, they both make those decisions, and it really is crucial. These are your kids, hey, it's important. You should both do those things, but that's not the case. In a lot of cases, essentially it was, one party or the other making those kind of decisions, and so it really didn't matter. You're not losing your rights as a parent if you don't have input for those things.
Well, I think it's going to take a long time for people to realize that the word custody is no longer really part of the system. But I think what's going to happen eventually is people are just going to replace those words. And someone's going to say, yes, she won allocation, or I don't have any allocation. It's a name, it's a word. It's not going to change the dynamic of who's doing what, correct?
That's correct. And that's probably something for our millennials, okay?
She out-allocated me.
Well, that's a good hashtag.
I got gypped on allocation.
Hashtag out allocation. That's pretty good, Dave. I like that. But essentially, again, that's why I said, rose by any other name is still a rose. And even people are still using it's the same concept, okay? But what it does is it lightens it, because look here, now we're talking about, just like before we used to have what they call removal. And that meant that, hey, listen, okay, two people are divorced, you have visitation, I'm the custodial parent, and, hey, I want to move to Arizona because my new spouse got offered this really wonderful job, and there's going to be this huge house, and, there's an excellent school district and everything, and so now instead of calling it, relocation or removal, it's relocation. So there's
same thing.
It's the same thing. It really is. And so, still, but that applies to everybody because the law changed. So judges and lawyers alike are the same. And I've even had some issues with not issues, but for the first time when you draft a modification of something, it has to be done in a different way. And truly, truth be told, with respect to the allocation judgment, there are a lot of new laws that kind of come into play. For example, if you live in various counties, you can't take the children and move more than 25 miles without doing a relocation request. And the statute sets out a whole program for you to do that. In
So
other
there's
words,
a border wall.
well, there's no border wall, okay.
Or a border.
Well, there's no border, okay. There's no wall, there's no border. But what it is if you want to move more than 25 miles away and you live in one of those counties, you have to first send notice that gets filed with the clerk and sent to the other side. And if they agree, fantastic, no worries, no problem, everything's good. If they don't respond to it within a certain period of time, then it's going to be granted. However, they can respond to it in a period of time, and then that's where you have your litigation. What's going to happen when you go in for something like that is they're going to send you to mediation. I'm a mediator as well as a guardian ad litem, and a mediator is an attorney, doesn't necessarily have to be, but generally they are, with specialized training. The mediator is a neutral third person, and that mediator is going to try to help the parties come to an agreement. The mediator is in control of the process, and the parties are in control of the outcome. And a lot of times the parties like that because, hey, it's not your attorney, it's not my attorney. Okay, hey, this person, I never met you guys before. Look, I just want to help you come to an agreement. And that's the first defense that they use.
So now you got two strangers deciding your fate. You got the mediator and you got the judge.
Mediator's not deciding your fate. The mediator is trying to help the parties come to an agreement on their own. And and a lot of times, hey, they'll be able to come to an agreement. And
I hope so.
If they don't, they don't. I mean, obviously you have to pay the mediator too, and it depends upon what county you're in, depending upon how, what the pay structure and everything is. But hey, that's the first. And if not, that doesn't work, then a guardian ad litem can be appointed. Guardian ad litem is, again, an attorney who has specialized knowledge and does an investigation and reports back to the court on to what that person believes is in the children's best interest. Now, there are three other things. I don't necessarily know that we need to get into them. There is a child rep, and then there is an attorney for the child. And that kind of, the child rep is kind of in the middle. The attorney for the child is just like an attorney for one of the parties, and the children are that person's client. Generally, they do that with older kids.
I think the important takeaway is for people to realize that it's just not the two litigants, their attorneys, and the judge. There's a lot of other people that get involved, Dave. And it's expensive.
It certainly can be, because if you're going to pay the mediator, okay, both parties, and they're going to allocate it depending upon the resources or depending upon what your initial judgment says, right? A guardian ad litem is going to have to be paid for his or her time, and either that person will do a written report or they won't. It all depends on the unique circumstances of the situation that is before the court.
Okay, let's talk about something here, Jesse. There's the judgment, which has the allocation part encompassed in there.
Sure.
I've seen a lot of these recently.
Have you seen one of mine, Dave?
They are voluminous.
Yes, they are.
They are like a Bible. There is so much in there. You'd have to go read it for several days to know who's responsible for what, who's not.
I don't know about that exactly. I will agree with you that it's voluminous.
Does that make it better? Or does that make it more difficult and more litigious in many ways?
Well, the more situations that you cover, the more you try to head off. Now, no judgment, I don't care who drafts it, is going to cover every situation that is going to come up in the lives of these people. Okay,
sure.
But if you have safeguards put into place that, hey, say if this happens, that happens, and you provide for those things, then hey, look, they can look at their judgment. And it's not really that, oh, they're never going to be able to read it. I go through the allocation judgments with my clients, and are they all the same? Kind of, but it depends upon the unique situation and what the agreement of the parties are. All right.
Are the judges reading these agreements in their entirety before they sign off on that order?
Well, it really depends on where you go, what county.
Cook County.
Cook County, and that would depend upon the judge. But I think that what's going to happen is, kind of need to explain it, and the judges are going to look for specific things like, okay, first of all, what is the general basic of the allocation? They're not going to go through this, 30-page document, all right? But they're going to want to know what's the basis, the basic terms of that allocation judgment. Who is going to be designated as the residential parent? Now, the only reason that you have a designation as a residential parent is because other laws haven't caught up. So for schools, it has to say, I'm the residential parent in order for me to be able to register that child for school. But here's the thing, in the allocation judgment, what it says is even though somebody's designated as the residential parent and the address goes in there, that doesn't give me an advantage in a subsequent litigation to say, oh, well, I'm the residential parent, and so that takes care of that. And that's what was happening before. That's kind of lighting that up, but you have to do that for, again, for school law in order to make that happen. You have so many other things in the allocation judgment that the judge is going to look at. He's going to look at, hey, what the address is. I mean, make sure that, okay, we had our county and, because again, there's certain counties, if you're within those places, it's 25 miles to be able to take your child to move without permission of the other parent. There are some jurisdictions, and I've come into some judges where they want a copy of the allocation judgment before they're going to sign it and they're going to read it.
Okay. Let's talk about something that hasn't changed by the new statute, and that's the division or allocation of property. How does that work between spouses that have acquired things during the marriage, now have gone their separate ways? One spouse might have contributed more towards an asset than another. How are things divided in the court?
So we talked about our allocation judgment. Now we have our either marriage settlement agreement. Hopefully you guys are going to come to agreement. And truth be told, most cases end up settling. All right, it's better for the people to have a vested interest in it and to come to an agreement than to have somebody else make a judgment that neither party is going to like. Now, one person may like it more than the other, but pretty much both parties. In fact, that's how we know that it's a good decision. When both parties don't like it, it's a good decision.
Okay. It's a perfect decision.
Perfect decision. And so you have a marriage settlement agreement, and so it really depends on the unique case and the circumstances. It depends upon what the parties make. It depends upon the assets that they have, the debt that they have. It depends upon any premarital assets that they have.
So where's the equality? Is there equality in the division?
Sure there is, and that's the whole purpose. The whole purpose, and again, it's a divorce. It's to allocate the assets and the liabilities in an equitable fashion. Now, what does equitable mean? Does it mean 50-50? Sometimes. Does it mean 70-30? Sometimes. Does it mean 80-20? Could.
That doesn't sound
sometimes
equitable to me.
Well, let me tell you. Suppose, Dave, and the courts are able to take into consideration non-marital property. And just for our folks at home, generally, and again, I just say this generally, everything acquired during the course of the marriage is marital property. And the same rings true for the liabilities, for the debt. Anything acquired during the course of marriage is marital debt. Now, we have exceptions with dissipation. If I spent $10,000, I took my girlfriend to Las Vegas, okay, well, it's not for marital purpose. And, we talk about dissipations. That's a little bit beyond our show maybe. But so with that accepting, so generally, that's kind of the way that things work. Now, if I have property that I own, let's just say, for example, I came into the marriage and, I had $1 million in stock and I never commingled it, I never transferred it, and it's just in my name and everything else. I don't need to do anything to maintain it. It's just losing, gaining. I had that before the marriage. Okay, that's my non-marital property. That's not subject necessarily to equitable division. However, the court can take into consideration the amount of that property in order to distribute the marital estate. So again, as I said, everything acquired during the course of the marriage goes in this one pot. Two become one, Dave, all right? As it says in the Bible, and that's how it is in the marital estate, okay? Whatever you make, whatever I make, that's what goes in there. Or it could be that even after we're married, I have an uncle or an aunt or grandpa or grandma or mom or dad who has passed, and they left me, not my wife, but me, an inheritance, and it could be anything, 100,000, 200, $1 million, whatever. And as long as I don't commingle it and don't put it in my spouse's name, right? It is still, that's going to be non-marital. Again, not subject to equitable distribution, but the court can consider that for dividing up the pie. So you said that 70, 30,
80-20.
or 80-20 didn't seem so fair. Well, okay, let's say that our marital estate is worth, $300,000, Dave, right? Okay. However, I have $5 million in non-marital assets. The court is allowed to consider that. And what's going to happen is that other spouse is going to get the lion's share. Now, a lot of this also, not so much with property, because again, if it's acquired during the marriage, but when we talk about maintenance and child support, which by the way is going to change, and you know what, I'm sure we're going to do a show on that, a little more detailed. So right now, Illinois has a statutory guideline. For one child, it's 20% of the net income. For two, 28. For three, 32. And the statute goes on. And that's of the net income. All right. So for maintenance, which is what they also changed when they changed the law, and they're making little tweaks to that too. And it's going to be changing. We're going to see them cleaning some things up, that unintended consequences, and just making things clear. So for maintenance, a lot of it depends upon, first of all, the court has to determine whether or not it's a maintenance case, and how long the parties have been married, and if they've been married long enough and the court decides it's a maintenance case. So what will happen is the court will take 30% of the payor. Payor is the person who makes payments to the other person. 30% of their gross, and they will take 20% of the non-payer's gross, subtract them, and that's going to be the maintenance. However, we also have to take into consideration any type of child support that the person receiving the monies, the payee, is going to receive, and that gets put in there. A lot of matrimony attorneys have programs that take all the guesswork out of it and make sure that you have the appropriate amount of taxes taken out of it, make sure that the people get credit for any exemptions, the dependency exemption, and all those things, because that could decrease the amount of tax liability.
It sounds like the court should be appointing a CPA instead of a mediator or a guardian ad litem.
I'm glad you mentioned that, because under the new law, the court can appoint financial advisors to help. They weren't able to do that under the old law, but they can now. And sometimes you have a situation where parties aren't playing nice, and you come across that. I come across that all the time. And so, based upon the petition of either party or even the court can say, okay, you know what, you guys are having problems. Nobody's putting the money in like they used to, and they're not doing and paying the bills. Okay, guess what? I'm going to appoint this person, this professional. You're going to pay all of your money to that person. They're going to pay all of your bills, and then they're going to give you essentially an allowance. But guess what? You're going to have to pay that person. There's also parenting coordinators too that the court can appoint in situations where the parents just get into, there really shouldn't be a reason to have to appoint a parental coordinator. Those are your kids. You're not going to use them like pawns. You're not going to do things and talk badly about the other party just to hurt them and to make them look worse in the eyes of your children. That is a horrible thing to do, and it just hurts the kids.
Do you think some of these laws and capabilities of the court will eventually have a chilling effect on marriage? As it is, we've got people that are not getting married to the same level that they married in the past. Children out of wedlock is getting more and more common. They would, of course, still be subject to the family law system. But do you think the marriage in it as a whole is being chilled on some of this?
Well, Dave, I think that if they made it as difficult to get married as they did to get divorced, that probably would happen. However, people are going to fall in love. They're going to want their special day. They want to get married. I've heard some of the same reports that people aren't marrying like they used to, but there's a whole lot of reasons for that. People are waiting. They don't, people don't want a responsibility of even having children, and that's okay. That's a personal choice. But you know what? People are always going to make babies, all right? And so we're going to have that again. Kids out of wedlock. But again, the law, I believe, is going to evolve. It just we're we're going in a direction. The whole purpose of that is to try to change it and to modify it so that it keeps up with what's equitable and with what's right.
Okay. Another governmental issue with divorce and minor children is the parenting class. Can you talk about that?
Sure. In order to get your dissolution completed, dissolution of marriage, all the counties require you to take a parenting course, which is about a 4-hour course. It depends upon where you go, depending upon the cost. Sometimes they'll allow you to do it online if you're out of state or something like that. I've seen those things happen, but it's essential. They won't even, they won't sign the judgment unless you do that. And basically what it does is it talks about children in divorce situations. And so children go through a lot of psychological drama as a result of their parents getting divorced. And hey, look, they love their mom, they love their dad, and so it's trying to instruct and to educate the parents on what the children are going through and what you shouldn't do. But unfortunately, again, people are so mean to each other and to the children, and they talk about the other spouse in a derogatory manner in front of the children and knock them down. And this borders on what we call a lot of times when we try to do a change in custody, or not custody anymore, but allocation of parenting time, of alienation. And again, it can get to a really, really chronic level where the kid is essentially brainwashed against the other parent.
Yeah, it just seems like the government is getting more and more involved where they weren't in the past. There wasn't a parenting class requirement in the past. You mentioned the child. I can envision one day where the child over a certain age has to submit to some kind of counseling or class. I mean, it's crazy.
Well, a child is a child, and if a guardian ad litem thinks that the child should be going to therapy or counseling, that person's going to make that recommendation to the judge and give the basis and the reason for that, and the judge in his or her infinite wisdom is going to make a ruling on that. And remember, it's just the child. It's not, okay, he's not my friend or my buddy. That's my child. It's not, look, I'm the one that's in charge. Parent your kid, all right? Parent your child. That's the important thing. What it's all about is what's in the best interest of the child. And unfortunately, the children don't know what's in their best interest. And unfortunately, sometimes the parents don't know what's in their child's best interest. All they sometimes think about is what's convenient and what's beneficial and what's right for them, and not what's right and in the child's best interest. And that's where the court steps in and says, oh, no. We're going to make sure that everything you do is in this child's best interest.
Right. Let's talk about grounds, costs, and time.
Okay, well, there used to be grounds of, we still
one.
have that, irreconcilable differences, mental and physical cruelty, adultery, habitual drunkenness, but now, when they change the law.
As opposed to seldom drunkenness.
Well, I mean,
Gotta be habitual.
it depends. I mean, hey.
But those are gone.
Those are gone, and so now.
Good riddance.
Good riddance. And also, the no-fault ground that we used to have, and we still have, and I'll explain, is irreconcilable differences. And basically, the parties just couldn't, can't get along anymore. They had to have lived separate and apart for a continuous period of time in excess of 2 years. But all of that, except for 6 months, could be waived by affidavit. Okay. Now, the only ground that you have is irreconcilable differences, and it only has to be a separation for 6 months. And it doesn't necessarily mean a physical separation. There's a lot of folks that still live in the same house, and maybe one person has moved to the attic or the basement or the guest room, and so they're not together anymore. Or sometimes they're even still in the same bedroom, but they're no longer intimate. They're not living as husband and wife anymore. They're just living as roommates. And so, the living separate and apart period of time has been calculated by, one of those things. And so it's only 6 months for that. And that's the only ground. And again, it's no fault.
Yeah.
So we don't have
well, in a way, I see the benefit of that because
Sure.
someone's not accusing the other of adultery.
Oh, yes, no. Yes, they do, Dave. They still do. It's just the ground.
Well,
okay?
the judge can strike
I've
it.
got some cases. No, but what I'm saying is, in terms of, I get people all the time too, and it really doesn't matter. And I mean, I know it matters to them, and I get it, and I explain that to them. But for purposes of law, hey, doesn't matter. Okay.
Right. Illinois says it's only irreconcilable
Only
differences now, and
irreconcilable
that's all you can go
differences.
with.
That's correct.
Okay. How about cost and time frame in the few minutes that we have left?
Okay. Well, I don't know how few minutes we have left, Dave, but I'll try to endeavor to explain that to you or for our people at home. Costs. It varies from county to county. Generally what happens is you file your petition for dissolution of marriage. There's a fee to file that. I'll get into that in a second. And then you place it either with a process server or with the sheriff. And the sheriff and process server, they charge based upon the location of where it's going to be served at. So you could probably expect at least a filing fee, if I'm just going to average it out here, okay, is going to be in excess of $300. And then what happens is when the other person, and then also for a service fee, you're probably looking at 50 to 60 to 75, again, depending upon where you have to serve that person. And then once the other person gets served with the petition for dissolution of marriage and the summons, they have 30 days within which to file their appearance and response or answer to the petition for dissolution of marriage. So, you know, it's really better for parties to agree. You know, here's the thing. It can go easy or it can go hard, but either way it's going. All right. And I always like to talk to the people that come to me and say, hey, look, you know, did you try counseling? Did you try to get together? Because that's the important thing. Look here, try that first. We can always do this. And a lot of times they've already tried that. And, hey, unfortunately, it's a dead marriage and we go from there.
Okay. And how about the time frame? How long are we looking at uncontested versus contested?
When we say uncontested, what we mean is that the parties are in agreement, okay? That shouldn't take too long, depending upon the complexity of the marital estate. So if somebody has, millions of dollars in assets, obviously that's more complex. If it's just a regular folks that, hey, maybe have their home and maybe have a child or two and retirement and things like that, and they're in agreement. Basically, you come to my office and you say, hey, look, we've talked about it. This is what we want to do, divide everything up. I'm going to have the kids. He's going to have parenting time for this. Okay, so then it's just a matter of drafting that and filing it. And very often we file everything together. We encourage the other person. I can only represent one party. And so it's usually the first party who contacts me. And we have different forms that the other person signs. And we even recommend them that they go to an attorney to seek advice. And they don't have to, but that's the recommendation. They sign off on that form that they understand. I don't represent them. And so in a situation like that where we have all that stuff and I draft everything and everybody's good with it, probably between 45 to 60 days. And I say that because there are some counties that you can't, even if I walk in and we're in agreement and I file it now, I have to wait at least 30 days in order to get a prove update. However, you're still going to have to take the parenting class, and that's going to have to be scheduled, and you're going to have to take that. So it depends on the availability that they have.
Okay. Which counties do you practice in?
I practice in DuPage, in Kane, in Will, in Kendall, in Grundy, in Cook. I've been to Lake for very special clients, and to Dundee or DeKalb, again, for special clients. I try to, you can't really do it all.
All right, but it sounds like you cover a very diverse area.
Sure
and
do.
You're willing to handle it in all those areas. Jesse, thanks for
Dave,
joining us.
thank you very much.
As always,
Thank you.
Great knowledge about divorce and family law. My co-host, Jesse Barrientes, I'm Dave Siegel. We'll see you next time on Legal Action. Take care.